Okay, welcome back. So we are getting started after spring break. I hope all of you had a good break. Today we have a guest speaker, John McNett. John has been a guest speaker almost every year in our class, and sort of at this time juncture, it's very appropriate. John is adjunct professor in the School of Mechanical Engineering for more than a decade now, I think, and has been, in my opinion, one of the most valuable additions to our school in terms of expanding and also creating this space where we acknowledge the importance of intellectual property. And John has contributed immensely to our curriculum, especially with this class, ME554. And a lot of students that take this class usually take that. So I highly recommend that class for you. And you'll find that it's going to be, many of you have done it before here? 1, 2, 3. That's pretty good numbers. So I would like to see all of you do it next time, especially all of you guys going to industry. And McNett, John McNett has a degree undergrad degree from Purdue and a law degree from George Washington University. And in particular, we have talked a lot in this class about creativity and insight. And patents are in fact a major source for both getting new insights as well as looking at what is there and understanding the past. And John has developed this unique class where he actually talks about how to think about patents and inventions, and therefore it relates directly to the subject matter of this class, product design. Also licensing of technology, and he has handled a number of very major cases, both in the US and outside. One of them is the Gatorade thirst quencher. Everybody knows that quite well, but also was a lead counsel for Thomson Consumer Electronics on the M16 assault rifle, and that has been cited recently in Supreme Court cases, as John was pointing out, and has been involved with satellite television and several other major happenings in the real world. And in terms of people that I have interacted with, I've interacted with a number of attorneys, during some of my patents as well as some of the startup areas that I've been involved with. John is one of the most knowledgeable people in terms of this area, but also in terms of sharing his knowledge to people like you. Not many attorneys can even translate the knowledge that they have in terms of what is important for students and how students can think about inventions and claims and so on. And so it's a really a very valuable service that John has done both for Purdue and for several students in the past. So thank you, John, and welcome back. So let's give John a hand. And okay.
Thank you very much. Okay. I would like to invite any of you along the way if you have questions to.
Oh, you want the other one?
Is this a better mic to use? I'd be happy.
You have the other one on.
Yeah, I'm got two now. So if one fails, you can continue with the other one.
Is it on?
Okay. As I said, I'd invite you to ask questions along the way if you have any. Be perfectly free to raise your hand. My primary role in life is as a patent litigator, and I'm very accustomed to being interrupted by opposing counsel and judges and whatever else. So please feel free to do so. I'll feel right at home. Okay, we're going to talk about understanding about patents with the premise that if you understand patents, it can improve your product design. And it can do that in several different ways. We'll come at it from a few different directions, but first, let's talk about what is the essence of a patent. The essence of a patent is the right to either exclude others or to obtain payment from others for use of an invention. Notice that this definition has nothing to do with what you yourself can do with regard to using your own invention. It only relates to what you can do to keep other people from using your invention. Patents are an exclusionary right, a right to exclude others. They're not an affirmative right that says you yourself can use your own invention. Whether you get a patent or not will have nothing to do with whether you can use your own invention. Whether other people might get patents that cover what you do might have an impact on whether you can use your invention. But what you get a patent for is to stop other people from using your invention. So that's really the essence of a patent. It's a government-granted right that keeps a person from freely making, using, selling, offering for sale, or importing an invention of another. And these are the various things that you can exclude others from doing. You can exclude others from selling your invention. You can exclude others from using your invention. Exclude others from making your invention. And they could do any one of those things and none of the others, and your patent can still exclude them from doing that or entitle you to the payment of a royalty as an alternative for the exclusionary right. There are three categories of patents. And the first one is really the dominant category that you normally think about when you think of a patent, and that's a utility patent. Utility patents only address the functional aspects of inventions. Examples would be Edison's light bulb and the Wright brothers' airplane. Most patents are utility patents. Second category is a design patent. Design patents only address non-functional aspects of an invention that are visible. An example would be a novel aesthetic shape of a television remote control. And the third category, which you probably never in your life will come across, but for completeness, it is a plant patent. Plant patents only protect asexually reproduced non-tuber plants. An example would be a novel rose or an apple tree. So we're going to break down today's discussion into three categories. The first is, what do I do if I have an invention? Second, what do I do if others have patents that might cover what I want to do? And third, can my product designs be improved in an innovative way if I better understand how to define inventions? Those are the three territories we're going to cover, and I'm going to start with the first. What do I do if I have an invention? The very first thing to do, and it is something that people avoid like the plague, I'm not quite sure why I repeat it over and over again, but instinctively, when you come up with an invention, the most important thing that you need to do to make an assessment of that invention is to find out what other people have done very similar to what you've done. It's only by making that comparison of what other people have done and what you have done that you can get any sense as to how your invention might differ from what's been done before, and as a corollary, how much patent coverage you're likely to be able to get. And when we talk about prior art, we're talking about the term used to describe all things that people have done before that are entitled to be used as evidence against a claim of novelty or patentability of a later invention. And what is prior art in one sense, in one country, might not be prior art in another country. So it's all relative to the laws of the country in which you're trying to make an assessment of the impact of a particular publication or action that might have been before your invention or before your filing date. A thorough search is usually necessary to provide a basis upon which to properly define the invention. If you don't have a good search done, there is no way that you can define your invention, because you don't know how broad you're entitled to cover it, because you don't know what else has been out there. If you have a really good search, you pretty much know the limits of the coverage that you might be able to get. Once a patent's coverage is understood, one can then compare it to competitive alternatives and consider whether there would be a big enough market for a long enough time to warrant the cost of a patent. There are a lot of techniques for searching that are available. The two most common are google.com/patents, which is a special search area in Google that lets you word search patents. And the Patent Office has a website as well, uspto.gov, that is frequently used as well. And there are some commercial services as well that allow you to search with different capacities for the Boolean searching in each of the different databases. You can also just print copies of patents with the 3 of the websites that are listed on the handouts. There are other searching resources. Most often in the mechanical areas and the electronics areas, searching the patent database will be adequate, but prior art encompasses not only patents, but anything that was published anywhere in the world prior to your date of invention, and actually now prior to your date of filing or your date of first publication that's within a year of your date of filing. In that instance, to try to find prior art, you can just do a basic Google search to see whether or not the product's on the market, being offered by somebody. See if it has ever been offered by anybody, and if you do find it on the market, and if you had invented it some time back, you can use something called the Wayback Machine at archive.org, and it will show you the content of the web at prior points in time, so you can see whether what is there now was in fact done at a prior point in time to see whether or not it in fact is prior art. Now the procedure for obtaining patents for people in the United States, the first step is to prepare and file a U.S. patent application. That might cost $10,000, and there would be additional costs and fees throughout the 20-year term of the patent that might add another $15,000. There's an option to file a provisional patent application at a much lower cost, but then you have to file a regular application within a year of the filing of the provisional application. And the standards that are to be applied for a provisional application are much lower in a sense because they will accept for filing a much lower standard application. But then later on, when you file your regular application, if you want to be entitled to that earlier filing date, you to sometimes are held to a higher standard than they led you to believe for the initial filing. And so you can get in trouble if you don't do a really good job on the provisional application. And the difference between the provisional and the regular application is that the provisional application doesn't start the 20-year time period that measures the term of your patent. Only the regular application starts that 20-year term. So you can have your patent last a year later by filing a provisional and then a regular application within a year. So that's really a significant advantage in some technologies. In other technologies where it's very rapidly changing, your goal is to get a patent quickly. And so filing a provisional would just delay the normal examination process, and so you would not want to file a provisional in those cases. There is a wide variety in quality and price for patent applications. Typically, quality is paramount, but not always. The cost to enforce rights in court is very expensive, often in the millions of dollars. There are administrative challenges to validity that you can do in the Patent and Trademark Office. If you think a patent was issued in error, you can pay money and have them re-examine the patent, and they can cancel the patent if in fact it was issued in error. And those are relatively inexpensive. If you want to get patents in foreign countries, because each patent only has coverage in the country in which the issuance was granted, that might be an additional $5,000 per country for the filing. And if it's Japan or Europe, then it would be $10,000 per jurisdiction. Each foreign country charges, in addition to the filing fee and the processing, maintenance fees every year. So each year that you maintain a patent in a foreign country, they're going to charge you a tax, a maintenance fee tax. And each year, during the life of the patent in those foreign countries, that fee gets larger and larger, so that at the end of the period that you have your patent, you're paying pretty hefty maintenance fees if you have a lot of countries that the patent has been issued in. Cost to enforce rights in court is substantially less overseas than it is in the United States. The United States judicial system is very expensive, but it is a very good system if you want ultimate truths compared to the system you get outside of the United States. Yes.
Question about Europe is, does that, European application, does that cover a group of the European Union countries, or is it each one individually?
You can get a European patent that has force and effect in a group of most of the European countries, those that have elected to participate in that process. And so the one patent works for all. Each country has its ability to separately interpret that patent, but it's just one process, one examination, one issuance. And so it's a much more efficient process than they used to have before they had a European patent.
So does that estimate of the litigation costs include settlement or just the court battle?
Settlements can be free, depending on, or it can be any price. So no, that's just an estimate of the litigation costs if you go through trial. Yeah, that's why obviously a lot of cases settle, because it's very expensive to do otherwise. Now there are some essential requirements, and you can't get around these. If you fail to meet the essential requirements for patenting, you cannot get a valid patent. In the United States, we now are living under what's referred to as a first-to-file system. And that's somewhat of a misnomer, but all of the other countries in the world require that you be the first person to file your patent application in order to prevail in any contest with someone else. And all of the other countries in the world, besides the United States, pretty much require that there be no public disclosure of your invention before your filing date. The moment that there's a public disclosure of your invention, then you lose the rights to file if you haven't filed by that time, everywhere in the world other than the United States and perhaps Canada and maybe Australia. But that's a major difference. And so to the extent you're trying to maintain worldwide coverage, it's very important that the patent application be filed in the United States before there's been any disclosure of the invention in a non-confidential way anywhere in the world. If you have disclosures in confidence where you have an agreement of secrecy, those don't count. But to the extent you go out, you've made your invention, you run out in your front yard and you say, "Eureka, here is my great invention," your neighbor overhears you, you've lost your rights to your foreign coverage. So you have to keep it secret unless your neighbor has this agreement with you to keep everything that you yell out in the front yard confidential, then you're in good shape. So that's basically the prime distinction. Now in the United States there's a special wrinkle, and that basically says if you do disclose it in the United States less than a year before you file, then that doesn't count. We'll not only not count that, but if you've made a public disclosure of your invention within a year from your filing date, if it's more than a year from your filing date, you're dead. There's nothing you can do to fix that. But if you file within a year from your first public disclosure, not only is that okay in the United States, but it extinguishes all of the intervening prior art that may occur between that date of public disclosure and your actual filing date, provided you file within a year. Sort of an interesting modification to the old rule that we used to have.
You touched on it briefly. I read an article last week that the patent system in the U.S. is changing from a first to invent, which is historically the way it's been, to the first to file. Now, how do you think that's going to change the landscape of the patent system? Do you think a lot of people are just going to go out and start patenting a whole bunch of, I shouldn't say random, but random ideas to have that in their pocket?
My belief is that the change will be imperceptible. It will be just a different rule, and where one person might have won one way, the other person might win, but that will happen very infrequently.
Okay.
In my career, in 43 years, I have had 3 cases involving an interference out of thousands of cases, and in none of those 3 cases would the law have made any difference had it been one way or the other. So I think it's a very minor point. We are now more in conformity with the rest of the world, which is probably better. That people only have to learn sort of one rule as opposed to two rules and keep them in mind, although our Congress has made this modification to our system. It isn't really first to file. If you had had an earlier publication within a year, then you can be last to file, and you can rely upon your earlier publication to get ahead of that other person. Yeah.
I guess I'm confused. Why wouldn't you publicly disclose if you know you're going to file within the next year?
Why would you?
Why wouldn't you?
Well, you don't want to lose your foreign rights. If you make a public disclosure, your foreign rights are gone. And so once you file in the U.S., you can use that U.S. filing as though it was your foreign filing date by treaty. And so if you file in the U.S. before public disclosure, then if within a year from then you seek your foreign coverage, you're golden, because you're entitled to your U.S. filing date for those foreign countries by treaty among countries. So the essence of the rule is, if you don't timely file, you lose your rights. If you do timely file, you're in good shape. And the earlier you file, generally, the better you are. There are some other considerations that are helpful to keep in mind. One is that the patent standing by itself is not nearly as valuable as a patent combined with a product that is being marketed. A lot of people think they can come up with a great idea, go to the patent office, get a patent, and not lift a finger about making a prototype or getting a product to the marketplace. And then they'll make a lot of money and they'll sit back and the royalties will come in. It rarely works that way. What really works most powerfully is to come up with a really good idea, build a prototype, get some samples in the marketplace, get some consumer acceptance, and then you sell that product line along with the patent in combination and make a lot of money, or you build your own business, or you license the patent with the validation of the marketplace behind it that you get from actually putting a product out. When you try to do it with the patent by itself, that's a much tougher path to go down. Now, if you've invented a new nuclear reactor, for example, nobody's going to expect you to build a nuclear reactor before you can license the patent. But for most things, you actually can develop a prototype, an example, and get interest from consumers, and then the patent takes on a lot more value. So you can think of the patent by itself if you want, but then the value tends to be less. And if you marry the patent with a marketable product, that vastly enhances the value that you can get from the patent as well as from the product. The product alone isn't worth much without the patent. The patent alone isn't worth much without the product. Having the combination is a very powerful combination. And sometimes the value of a patent is to simply use it in negotiating for rights in other people's patents. You really don't want to spend $1 million to enforce it against infringers. You want to have it in case somebody tries to assert a patent against you. You can say, now wait a minute, you assert your patent against me, I'll assert my patent against you. How about we cross-license and not worry about it? And so the patents provide sometimes a defensive value more than a royalty-generating value. Now this is the second part of the discussion. This is a really tricky one that people have a very hard time with, and that is, how much is my patent worth? If I license it, how much royalty should I charge? If I sell it, how much should I sell it for? How do I determine what this patent is worth? I've got this right to exclude other people from making this feature, but now I have to translate it into money. I have to monetize this, and what do I do? This question permeates the design process, because anytime you design something, you have to be able to calculate, is there a dollar amount that I'm going to have to put in the valuation to pay somebody else's license fee, or can I charge more for my product because I can exclude others from this feature? And so when you do the economics of the product, what price point to put on it, you have to take into account both your own patents and other people's patents that might be infringed. The cost of a license, or the potential revenue from a license, needs to be valued reasonably accurately to be able to optimize a design for the least cost and to determine an appropriate sales price for any design impacted by the patents. Now, it may well be that you know of another patent out there that you're pretty sure if you put that feature in your product that you're going to be selling, they're going to sue you for infringement. And you probably think you can work out a licensing for a certain dollar amount, but there may be a design alternative that you can go to. Might cost you a little bit more, but it might still be less than the royalty you'd have to pay. And so that goes into the economics of optimizing your design. Are you going to want to pay more for the patent license, or are you going to want to adopt a design alternative? And then if you design an alternative, it may well be that you could get a patent on that innovative alternative. And so that you would not only be freed from giving money to your competitor, but you might also then have some protected space yourself for your product where it will have product distinctiveness that would be very helpful. The value of a patent is a function of how much more profit it can provide compared to other alternatives not covered by the patent. It's really pretty simple. If your patent cannot allow you to make a product less expensively or one that can be priced higher, then your patent has no value. I mean, it may be something you're proud of, coming up with this great idea that doesn't provide any economic value to the customer. And you may want to be able to say patented because you think it will help your marketing. And to some extent there is some modest value there. But for the most part, we disregard that in valuations. The rule of thumb is that the value of a patent to an inventor is about 1/3 of the increase in profit that the invention provides, with the manufacturer who actually produces the patented product being entitled to the remaining 2/3 of the increase in profits. It isn't always that way, but that's a pretty good rule of thumb. And so if you want to roughly figure out what the patent is worth, that's the starting point. Now, if we go through the process more specifically, the first thing that you have to do is find the closest, most effective alternative design which does not require a license. And then you compare the economic differences. Assign a royalty value of 1/3 of those economic differences. And then you have to do some adjusting that would relate to facts unique to this particular invention. You might adjust downwardly based upon special risks of invalidity or unenforceability. Now what I mean there is, it may well be that you've got this patent, but after this patent issued, you came across some prior art that's really pretty close to what this patent is covering, and you're not really sure if put to the test your patent would hold up in a court challenge. In that event, you might want to lower the royalty rates that you're going to be charging because you recognize that it may well be that you might get 0 if you press the matter. Sometimes you adjust upwardly if, in fact, you're going to be granting an exclusive license to somebody. The exclusive license prevents you from licensing somebody else, so to get the reasonable value for your invention, you need to get more money from the one company that you are licensing. You can also adjust based upon unique industry practices, if any, and I'll outline those a little bit. In some industries, particularly the automotive industry and the consumer electronics business, where there are a large number of patents implicated in each product that gets sold. When a car is sold, there may be hundreds of patents that are implicated by the sale of that car. Television receivers may have hundreds of patents implicated in their design. If there are large numbers of patents involved, and if it's a consumer-based product like cars and televisions, where price is very important in the sale, you really can't pay high royalties for each of those hundreds of patents and have the price of the product be reasonable for people to pay. And so those industries work very hard to establish precedents for low royalty rates. And you may have Sony on the one hand and Samsung on the other hand, each with 500 patents relating to television design, and they may cross-license those 500 patents each to one another for a 1% royalty for 500 patents. And by doing that, they try to establish a very low royalty rate for their patents. And the reason they do that is because they're fearful that some third party might come up with a patent and assert it against them and ask for a really large royalty. And their defense is going to be, no, nobody pays those kind of royalties. Ladies and gentlemen of the jury, royalties in this industry are always low. Therefore, we shouldn't have to pay this new infringer a very high amount of money because all these patents are worth very little. And so they want to have the image that the patents are not worth much. They establish that by their cross-licensing, and that seems to work well. There are other occasions where you might have just two players in the industry, each of which has several patents, and each of which infringes one another's patents. And so they're going to have to cross-license. They can't, either one of them, sell product without risk of infringement. But what they both really would like is for nobody else to come in as a third competitor. And so what they will do in their cross-licensing arrangement is say, these are really valuable patents. They're worth a whole lot of money. I'm going to cross-license you for a 60% royalty. You cross-license me for a 60% royalty. We both have very large sales. It'll be a wash. Anybody else comes in, they're going to be facing 120% royalty to get a license under both of our patent pools. And that works really neat in order to have the opposite effect from the analytical process that I first outlined, where you just calculate the difference and divide by 3. They have a much higher standard that they would like to tell the jury. Look at all these high royalties that we're collecting on our patents, and this new person coming into the marketplace trying to compete with us, they want to get this sweet deal where they pay only 5% royalty. I don't believe it. We're paying 60% royalty on these, and we're getting 60% royalty on our other patents. So that works out really well in a cross-licensing situation.
In a market of duopoly, can they be construed as price fixing of sorts?
Whether that has an antitrust implication that you're not, but it isn't really, because there's not an agreement between those two people that they will not license third parties at any different rate. I mean, they probably will, because that's sort of the rationale behind why they're doing this, but I don't really think that would constitute an antitrust violation by itself, to improperly be paying one another higher royalties than you should pay. If there was an agreement between the parties that they would go out and enforce their patents at those higher rates, that would be a violation. You cannot have that agreement between two competitors to enforce patent rights against a third. But if there's no such agreement and they're just doing this each with the knowledge that it will enhance their own individual positions against third parties, then that's okay.
Would it be something to do with reasonable? Can it be reasonably construed as,
If I may say? Yes.
You can make the argument,
yeah,
but I
okay.
think that would be hard to prove. I mean, if you had a letter saying, look, we're doing this, even though we know it's not true, I could imagine a set of facts where you might be able to establish an antitrust violation there, but people aren't that dumb as to put those things in writing. So, and I think it would be really hard to make that proof, absent some direct evidence that the two parties together are agreeing to assert their patents against a third party, which that would have crossed the line, and that would be an antitrust violation. But just to merely enhance the value of your patent, that's in everybody's best interest, to enhance the value of their patent as best they can and get as high a royalty as they can. So Yeah.
So one of the challenges, I think, is comparing economic differences, especially in the new market or with a situation where you just have limited information. Do you have any advice on how an individual might compare economic differences?
Well, it's different in each situation, and for some inventions, you can't really do it very well. This model of how to calculate this works most of the time in many situations. It is not universal, and it's just a guideline to think about it. But any product that's going to be sold, you're going to have somebody telling you what the price point should be for selling it. You're going to know your cost of materials, so you're going to know your gross profit. There are going to be some competitors doing something somewhere that's going to have another gross profit margin. You can compare those two and subtract and divide by 3. That's inherent in any product that gets sold. Is there some cost of goods and price that the product's sold for? And you can subtract those. It's not too hard. It's basic arithmetic. But the problem arises that you're probably alluding to is that sometimes the alternatives in the marketplace aren't really exact replacements, that you have some advantages that make them a little bit different and they aren't quite so comparable. And you just have to estimate when that happens as best you can. It's not a perfect process. Okay, once you've got this difference calculated by 1/3 of the difference in profitability, not 1/3 of the profit, but 1/3 of the difference in profitability, then you convert that to a royalty rate. And the reason that you convert it to a royalty rate is that accountants can't fudge unit sales or dollar gross sales. Accountants can fudge profits very easily. So even though we're doing the calculation as to how we come up with the value of the royalty, once we've done that in a pure setting, we have to convert it to a royalty rate on something that accountants can't fudge. And so normally that's done as a percentage of gross sales or number of dollars per unit sold with an inflation adjustment so that the dollars per unit sold stays constant in real dollars. There are oftentimes variations where the royalties change, not oftentimes, but occasionally, where royalties change with volume or time, and there are rationale for it going up over time and a rationale for it to go down over time, depending on the setting. But for the most part, you come up with a fixed royalty percentage, and that stays throughout the life of the patent, barring market forces that force a revaluation. If the license is exclusive, you then select a minimum yearly royalty or minimum yearly sales, and sometimes there are advance payments that are made in order to have the license take effect. You generally only have minimum royalty amounts and advance payments if the grant is exclusive. If the grant is non-exclusive, you rarely have minimums in licensing arrangements. Getting an invention to market is the hardest part. Inventing is typically relatively easy. Patenting is somewhat more challenging and somewhat expensive, particularly if international coverage is desired. But getting an invention to market is generally the hardest part. I mean, it's really easy to come up with great ideas. You sit back, oh, wouldn't it be neat to have a machine that defies gravity? Isn't that great? Actually, building one is a little more tricky, and getting a patent on it would be hard as well. But a corollary to all of this is don't be overly concerned that someone will steal your invention. It may be the best thing that could happen to you. A lot of people say, I've got this great invention, I don't want anybody to know about it, I'm really worried about somebody stealing it. Once you've got your patent on file, let them steal your invention. I can tell you that if I'm your trial lawyer and somebody stole your invention, I've got a good story to tell the jury, And I'm probably going to get some really good damages from that. And your negotiating position is massively better if somebody stole your invention than if they independently came up with it on their own, didn't even know about you. If you can imagine a subdivision where they're building houses all over the place, and you bought one of these great lots in this subdivision, you think it's just a perfect place, and about half of the lots are filled with houses and half of them are not, and you drive through one day and you see somebody building a house on your lot. I would ask you, do you think you'll be able to get a better price for your lot if you want to sell it to the person who's building a house on it? What negotiating power do you have if they're building a house on your property? It's the same thing with regard to inventions. Don't be so bent out of shape that somebody's going to steal your invention because they're giving you a ticket to enhanced negotiating power to get a licensee. You may not want a licensee, but on the other hand, they may be more effective at getting the product to the market than you would have been, and you may end up with a lot more money from somebody who stole your invention than you would have if you had tried on your own. Because the hardest part is getting the thing to the marketplace. Somebody does that for you, you should thank them, and then take the big check to the bank. Okay, another category. What do I do if others have patents that might cover what I want to do? There are many options here, and usually people think about a few of them, but they rarely think about all of them. The first and most obvious is change your design. Change your design to something that's no longer covered by the patent. And in doing that, I've seen it happen time and again where the design alternative itself is even better than what you'd first thought of, and itself is patentable. So you can end up trying to avoid a problem, ending up with an asset that's better than you would have otherwise even thought about. Second, you can license from the patent owner, or you could purchase the patent. And then the valuation that we talked about earlier is a very important consideration. The third, which is what happens most often, is that you invalidate. And typically that's done by finding prior art that was not considered by the patent office. You say, this patent never should have issued. It's trying to cover something that was done before, and it was a mistake. And once you have this piece of prior art that you find that's really better and shows exactly what it is that the patent was trying to claim as their own invention but was done earlier, then you don't have to worry about the patent. You can just ignore it, and if they come after you, say, look at this piece of prior art, go away. Or if you want to really ensure that they're not going to come after you, you can file a request for re-examination, tell the patent office about this new prior art, and the patent office will do that for you. And the fourth is another thing that we do from time to time, and it's just ignore the patent. Don't worry about it. Particularly if you have offsetting exclusionary rights of your own, or you're not otherwise on the radar of the patent owner, perhaps due to your small size or your different market focus. Now, if you're going to start a business and immediately take away the prime customer of the patentee, that won't work. But it will work in most other circumstances, particularly if you are innovative yourself. If you're not really just copying what the other person did, and you have your own improvements and your own advantages, then if they come after you and you really have these other advantages, you've got something to cross-license with them so that they can then adopt your advantages, you're adopting their basic technology. And that tends to be how most of these things work out. With regard to designing around, knowing the patent coverage of others gives the designer an option to consider, and particularly if you know the patents of others early in the design process, it can provide significant savings in legal costs or licensing fees. Now, there's a difference in how to react to patents of others depending upon the industry in which you work and how much money you are going to invest in your product before you start to get a return. If you are a pharmaceutical company and you're spending $20 to $100 million to develop a new drug. The last thing you want to do is ignore a patent of somebody else that might be infringed after you've spent $100 million developing your new drug. You want to take care of that problem up front, or you want not to invest that money. So if you're a pharmaceutical company, they rarely ignore other patents. They almost always very thoroughly search for other patents, and they almost always make sure that they're not infringing any other patent before they even go forth with their very expensive development process. Generally speaking, with pharmaceutical companies, there's only 1 or 2 patents total that are going to be involved in the product. So it's a simple matter to get it resolved. The other end of the spectrum are automotive companies. They rarely consider risks of third-party infringements. There are numerous patents related to each product, and they have great market power to keep patent owners in line if they ever want to do business with the automotive companies. So they look at it the other way around. They say, we'll deal with any patent problem once a lawsuit is filed against us and we've examined it and it looks like we might lose. Then we'll get serious. Until then, we're not really going to get serious. And if it's one of our suppliers, they're not going to sue us. So I'm not going to worry about it. And it seems to work pretty well. Now, if you're a little company, you often do not have to consider the risks of third-party infringement unless they're really clear, because what's this big company going to do? Are they going to hire a law firm and commit $1 million to go after $10,000 in damages? I don't think so. I think they'll just ignore you. Maybe, maybe not. But that tends to happen more often than not. That little companies are really under the radar, and until they get big and until they are a significant threat to a significant customer, they generally don't have to worry quite so much about patents. Now, with that approach, there are risks. If you ignore patents of others and you're found to be a willful patent infringer, the courts can multiply the damages times 3, and they can have you pay the other side's attorney fees. Well, if you're a really little company, your corporation doesn't have the assets to pay that stuff anyway, so there's really not that much of a threat to that. That's what the law provides. And courts frequently find that a patent is either invalid or that it's not infringed. So statistically, if you're really forced to go through the battle, you've got a shot at winning anyway. If you have your own innovations, you've got a cross-licensing tool to make the problem go away. Now, the last category for discussion is, can my product designs be improved in an innovative way if I better understand how to define inventions? And the premise of my ME554 course on intellectual property is that it can. And that if you really understand how to write patent claims, or at least what the thought process is involving the writing of patent claims, it will make you think differently in the design process so that you will be a better designer. I use as one example a fellow by the name of Albert Einstein. From the age of 23 to 30, Einstein worked as an examiner in the Swiss Patent Office in Bern, Switzerland. His job was to understand and deal with definitions of inventions and discoveries. He had every day training on the analytical thought that goes into writing patent claims, interpreting patent claims, understanding patent claims. At the age of 26, while still employed as a patent examiner, Einstein made 3 of his greatest contributions to scientific knowledge. And I've listed the 3 papers that he did after working for 3 years in the Swiss Patent Office, working with patent claims. It was not until Einstein was 30 years old that he held any academic position. Well, it wasn't an academic path that gave Einstein his insights. It was a path of analyzing patent claims. Another example is Chester Carlson. Chester Carlson was laid off as a research engineer at the Bell Telephone Labs. And he worked briefly for a patent attorney and then got his own law degree and became a full-time patent attorney. He became very skilled in understanding patent claims and the invention process. When he was 31, he filed the first patent application on the Xerox machine. Before his death in 1968, he had given over $100 million of his resulting wealth to charity. And I will guarantee you that Chester Carlson would not have ended up where he ended up had he not spent a lot of time analyzing patent claims. He wouldn't have thought to go about the process of developing the xerography technology had he not the understanding of patent claims. The interesting thing about dealing with new inventions, unlike most everything else that you've done in your educational process, is that with new inventions, you can't look it up anywhere to find out about it. Everything else that you deal with, there's some body of technology you can look up and see what the answer is. Some researcher somewhere has spent a long time figuring it out, and there it is, and you find what he did, and then you can apply it, and life goes on merrily. Every invention that a patent attorney deals with, every new invention that you're trying to claim, is something for which there is no answer elsewhere as to how to define that invention, how to deal with that. It is a completely different approach to learning than you have in your other curriculum. You can't even look at prior patents that have issued in the same technology. That is one of the most misleading things you could possibly do. Because there again, you're looking at something that's already been done. It won't help you at all in defining this new invention, because the people that did that old one had no clue about this new invention. If they did, they would have put it in their patent and you wouldn't have anything to patent. So in order to define a new invention, there are basically 3 steps that you have to take. First, you have to find the factors that distinguish what it is that is in this new invention when you compare it to the prior designs. And the second thing is to determine the appropriate level of abstractions for the terms used in the definition that you're trying to write. And thirdly, to create an invention definition from the abstractions determined. Now we'll go into this a little bit more, but this is the basic idea as to how you deal with defining new inventions. Now when I talk about abstractions, I can give an example here, and there's a hinge shown in the upper right-hand portion of this slide. And you could define that hinge very narrowly, at a very narrow level of abstractions, very precisely defined invention. It could be a Schlage model 1011F large door hinge with a 3.5-inch radius corner. That's very specific. And if that's what you got for your patent claim, somebody could avoid it by getting another brand hinge that might look the same, because you've defined it as this particular brand. Or you might get it with a 3.4-inch radius corner, and that would avoid this claim. So defining it narrowly like this doesn't really give you much protection at all. It's very easy to avoid. You can just change any little feature. You could also have another narrow definition that says brass door hinge having 2 plates connected with a hinge pin and 3 holes in each plate. Now that would be broader, because then if it's not made by Schlage and made by somebody else, or it has a different model number, you'd still get some coverage, but still it would have to be brass. And if somebody came out with a stainless steel version, or a copper version, or a bronze version, then they would be free of infringement. Or if it had only 2 holes in each plate, then that would avoid infringement. So that's still a little bit too narrow to be of a lot of value. Suppose you use a medium scope of abstraction, where you define it as a metal hinge having two plates, each having at least one mounting hole. That's a little better. That's even broader. It's got a higher level of abstraction. But even that, does it have to be metal? Is there a plastic version that might work, or a ceramic version? Do we really need to have mounting holes at all, or can we use an adhesive material to stick these things on with, rather than having holes? And does it have to have a hole? Can it have slots instead of holes? So even medium might not be the best level of abstraction for giving the coverage that you'd like to have. You could get broader coverage. You could just define the invention as means permitting pivoting of a first member with respect to a second member with 1 degree of freedom. That sounds pretty good. I'd like that coverage, because that would be much harder to design around. And the broadest level of abstraction, or at least one very broad level of abstraction, would be to define it as mass. That's a really pretty broad level of abstraction. I suspect there might even be broader levels, but that comes to mind as being one of the broadest levels of abstraction. So for each attribute of your invention, you've got this whole array of different levels of abstraction that you can use when you define the invention. And it's somewhat of a challenge to decide where to pick the right level of abstraction for the purpose of getting the coverage that is appropriate. And of course, you want the broadest level of abstraction that you can use in defining the invention, provided that it doesn't cover the prior art. The one requirement for defining inventions is that that definition cannot read on the prior art. The moment it reads on the prior art, then it's an invalid definition and it's no good. So then you might have to narrow your level of abstraction for some or all or different parts of the invention. You maybe have to add another limitation or some other feature that you put in so that it avoids reading on the prior art. And that's why the most important piece of this whole process is collecting in front of you, when you're trying to define the invention, the closest prior art that exists as best you can find it. That's why the search is so important as the very first step. Without that search, collecting all this prior art, you've got no way to pick the levels of abstraction that are appropriate to write the invention definition. For engineers and scientists, distilling an invention to clearly defined terms clarifies further thinking about the invention. The process of going through and deciding what levels of abstraction to use is a very helpful mental process in coming up with design alternatives or optimizing an invention. Invention definitions, once you come up with them, are at the core of patent licensing. And in patent infringement lawsuits, you go through the same process even though the patent is issued and the patent has already got patent claims, because sometimes you can come up with better definitions that are actually in the patent that are helpful to persuade the jury as to what the real invention is in comparison to what's in the prior art. And so this process is a perpetual process that goes on anytime you're thinking about intellectual property, trying to understand what an invention is, how much you can charge for it, how can you design around it, how can you improve your own invention. Understanding what that scope most appropriately is in a word definition is a very helpful discipline for all of those ends. Now, in the process of writing these definitions, which patent attorneys refer to as claim drafting, we do it by way of example with simple mechanical inventions, assuming a specific primitive collection of prior art. I'm sure you've all had the basic physics where you've studied the principles of physics, and they do that through the use of massless strings and frictionless pulleys, none of which exist in the real world. But when you apply those arbitrary characteristics, you can then focus on the essence of the physics principles. And we do the same thing in trying to understand claim drafting, where we will use hypotheticals with very simple systems so that you can understand those concepts. Now here's the first example. Let us pretend that there's no prior art of any type. So we've done a search and there's nothing there. We've entered our query into Google and nothing comes up. This red seat chair was just invented. Now this is what we're supposed to write an invention definition. How do we define this red seated chair in the broadest way possible to give us good coverage? Well, when we do our search, we don't find anything. Most people say, okay, I'll define that chair as something with a seat, 4 legs, and a back. That's a simple way. You say that, you know that it's a chair. But that's not a very broad coverage for the chair. That describes the chair, but not in the highest level of abstraction that's warranted, since there is no prior art. Now, if a person later comes along with a backless 3-legged stool, their product wouldn't be covered by that definition, because our definition required a back and 4 legs. And so that 3-legged stool would avoid infringement, and we wouldn't get coverage of that later development. And the stool can compete with the chair for having something for people to sit on. The marketplace would be perhaps even like the chair better because it's more efficient, it's more stable. The 4-legged chair has to be on flat ground. The 3-legged chair can be on a little bit not flat ground and it won't wobble. So the 3-legged chair, the 3-legged stool might be argued to be an improvement over the 4-legged chair. And you wouldn't even get coverage of that improvement if you had defined it as 4 legs, a back, and a seat. Now, if instead we defined the invention as a seat with 1 leg attached to it, that definition applies to the chair. We could adopt that definition. We would have a definition that would be much broader and more suitable to our hypothetical inventor of the chair. So the thing that's in italics at the bottom is our invention definition does not need to include all of the parts of the chair. It only needs to include enough parts to avoid reading on the prior art. And in our hypothetical, there was no prior art, so we can do really well with that definition by just simply saying a seat and a leg is the invention. It's not our task to describe all the parts. It's only our task to describe something that reads on the invention that does not read on any of the prior art. And the broader you can get that to be, the better your patent claim. Now let's change the hypothetical. Forget everything we just talked about. And we're now going to assume that the prior art includes the backless 3-legged stool. We did our search. That's what we found in the prior art. We've invented this 4-legged chair. Admittedly, the 4-legged chair isn't quite as good because it's not as stable, but it has a back you can lean against. And the 3-legged stool doesn't have that, and so we can argue an advantage because we've got the back. And also the 4-legged chair, if it's on a flat surface, will have a little bit more stability than the 3-legged stool. So we have a stability advantage on a flat surface, and we have a back, and so it's really quite an improvement over this 3-legged stool that's in the prior art. Now, our initial definition, where we said a seat, 4 legs, and a back, is starting to look more reasonable, because we have to avoid reading on this 3-legged stool. But that definition is still unnecessarily restrictive. It contains 2 items not found in the prior art: a back and an extra leg. Eliminating either one of these restrictions from the definition would make the claim broader, and it would still avoid the prior art. So, the better definitions would be a combination having a seat with 4 legs attached to the seat. And that definition makes no mention of a back, because you don't need to in order to avoid the prior art. You can just define it as a seat with 4 legs. Or you could say a combination of a seat with a back coupled to the seat. That's the second definition. Either of those would be fine, because they wouldn't read on the 3-legged stool in the prior art, and would still give you some decent protection. Now, other definitions from that chair is, you could say, a red seat, because the prior art isn't red. Or you could say a red substance. Why even limit it to a seat? You can have the level of abstraction much larger. And a patent claim on a red substance would be really valuable for somebody who invented a four-legged chair with a back. And it's very hard for people to think about when they see that four-legged chair with the back that has a red seat to claim as the invention a red substance, because they're thinking so much about the concrete example of this thing that they're looking at that has a back and four legs. But after a while, you start understanding that thinking more abstractly can be very powerful. And yes?
Would it be possible to include the different attributes as like different embodiments? So could you say, I have some seat that may or may not have four legs? Well, no, I guess we can't say that because then it's covered under the three leg. But like for it may have one, two, or four legs, and the seat, and another embodiment might be the seat may have a back.
Okay.
Or it may not have a back.
The ultimate of that, if you carry it to its extreme, is my invention is anything but a three-legged stool. Sure. And you can try that. At some point in time, the use of negative limitations will get you in trouble. And the patent office doesn't really like negative limitations too much. Occasionally you can slip them in. But that's the ultimate. And so your thoughts are correct analytically, but as a practical matter, if I say a device with something other than three legs, or 1, 2, 4 or 5 or more legs, but not including 3, you can do that. And there may actually be, in some circumstances, an argument that should be a valid patent claim. Because it may be that people in the past thought you had to have 3 legs because stability is critical. And you may say, no, nowadays people have flat floors, so it doesn't matter, 4-legged chairs. Actually, 5-legged chairs are even the requirement now for office desks because they're more stable than the 4-legged ones. So you could make arguments, perhaps, that something other than 3 is better than 3. And you can file different patents. You can have one patent on 4 or more legs, and another patent on seats with backs. And so, yeah, you can go at it a lot of different ways. There's no limit to the number of claims that you submit in a patent application. I had one with 114 claims. So you can get a lot of those. Final comments. The preceding samples of patent claims hopefully will give some insight into the analytical process involved in writing invention definitions. That's really what this is about, just to give you a sampling of what this is about. In the real world, sometimes it's easier. Most often it gets more complicated than these simple examples, but you really have to understand the fundamental principles from these simple examples in order to then be able to shift to the more complicated real-world examples. It's no different than in physics. In physics, when you get into the real world, you actually do have strings with mass and pulleys that do have friction, and you get more complicated equations. But to really understand the principles, you need to go at it with these simplistic approaches. So are there questions beyond that? Yes.
One thing I have trouble understanding is how to tell when an invention requires multiple claims in one patent or multiple patents. And I guess the example would be if you had your four-legged chair with a back, would you have one patent on a seat with 4 legs and one patent with a seat with a back, or would those be 2 separate claims in one patent?
The process that is optimum is to file them all in a single application if there are no conflicting questions about ownership. If there's joint invention and one person invented the legs and another person invented the back, and the ownership of the patent might go one place, that's a reason why you might not do it that way. But if we don't have an invention ownership issue and that same person invented all the features, you would universally put them all in one application. Now, if the patent office, in examining the patent, said, this is too hard for me to search both backs and legs, my job as an examiner is to search patents on legs. There's another examiner down the hall that searches patents on backs. And so it's too much of a burden. You only paid one filing fee. I'm going to make you divide this into 2 patents. They can make you do that. You can pay 2 fees and then they're happy. But when they make you do it, you get procedural advantages. And if you do it yourself in advance, you can sometimes be charged with double patenting, and that's your fault. If the patent office makes you do it, it can't be your fault. There's no problem. So normally you try to file them all in one. It's less expensive generally because you pay one filing fee. And later on, when you come up with the problem of the examiner saying there's 2 inventions here, it's simple. You just file another patent application based on that first one, and you have 2 of them, and they both issue. And so that generally is not the problem. If you anticipate it yourself and do it in advance yourself, then there's a risk of double patenting that could be charged if your judgment is different than some court later on might have as to whether they really are the same or different. So you normally put them together. Yeah. Another question?
I had a question about kind of about royalties. So in the United States, if you work for a corporation, you get a patent. Your name is on the patent, but the company owns that patent, right? I have heard that in other parts of the world, the company would still own the patent, but if your name's on it, you get some royalty. Is that true, or is that?
That is true, and that is true particularly in Germany. There is a pending law in the United Kingdom to make it true there.
Okay.
I would advocate for adoption of that rule in the United States as well, but it's not the law in the United States. Now, I will say that your premise is not as refined. If you work as a design engineer for a company, your obligation is to assign the inventions for which you were hired to invent to the company.
Okay.
If you happen to be a secretary in that company and you come up with an idea, the company doesn't get that idea unless you've signed a paper that says, I agree to give you all of my inventions during my period of employ. All large companies have you sign those papers. Mm-hmm. Now, occasionally there are wrinkles to that, and we had a case where a person was hired from a temp agency to fill in for a couple of weeks in the engineering department at RCA, who was working on the video disc technology. And the temp person wasn't hired as an engineer, they were hired as some clerical function. And while they were there, they came up with a really great improvement for how to make that video disc. And because they had not signed those normal employment papers that they require all their regular employees to sign, that temp person had the right to file the patent, and they did, and our firm got that patent for them. And then we negotiated with RCA to pay a royalty on the invention that that temp person had come up with that they put into their video disc technology. So it is not a given that just because you work for somebody, you owe them your improvements and inventions. But if you are hired to invent, as that's your job, if you're hired as an engineer, as a designer, then you would have that obligation implied by law. Yeah.
On that same sort of idea, if you develop something that was unique and then you went on later to work for a company,
I'm not quite sure of the hypothetical. If you came up with an invention while you're at Purdue or whatever, and then you get a job somewhere else and they're working on a competitive idea.
How would the like intellectual?
Well, a person is not entitled to the inventions that you had before you started working for them. So you would own the rights of the inventions you had before you started in their employ. I had another case like that as well for someone who was working in academia and came up with a really great molecule. They were MD, PhD researcher. And then they got a job for Eli Lilly. And Eli Lilly was interested